आयोजित केलेल्या प्रिपरेशन फॉर एक्झामिनेशन ऑफ फॅमिली जज या ऑनलाईन लेक्चर सिरीजच्या उद्घाटन सोहळ्यात उपस्थित असलेल्या सर्व मान्यवरांचे महाराष्ट्र आणि गोवा राज्य वकील परिषदेच्या वतीने मी सहर्ष स्वागत करते. गुड इव्हनिंग एव्हरीवन. On behalf of Bar Council of Maharashtra and Goa, I welcome Honorable Srimati Justice Revati Mohite-Dere Madam. I welcome Advocate Vivekananda Bhagye Sir, Chairman of Bar Council of Maharashtra and Goa, Advocate Dr. Uday Wadgurkar Sir, Vice Chairman of Bar Council of Maharashtra and Goa, Advocate Judge Zaibave Sir, Member of Bar Council of India, other members of Bar Council of Maharashtra and Goa, dignitaries and participants. I welcome all to this inauguration program of online lecture series organized by Maharashtra Bar Council of Maharashtra and Goa. Now I request Advocate Bhagye Sir, Chairman of Bar Council of Maharashtra and Goa, to give inaugural speech. Over to you, sir.
आदरणीय रेवती ढेरे मॅडम, आदरणीय जय भावे साहेब, आदरणीय निंबाळकर सर, या उपक्रमासाठी कष्ट घेतलेले माझे सहकारी आदरणीय डॉक्टर उदय प्रकाश वारुंजीकर आणि सर्व सहभागी वकील बंधू आणि भगिनींनो, न्याय संस्थेमध्ये सर्व लोकांना जलद, तातडीचा व स्वस्त न्याय देण्यासाठी न्याय संस्थेबरोबरच बार काउन्सिलची देखील भागीदारी आहे आणि ते बार काउन्सिलचं एक काम आहे असं बार काउन्सिल समजते. त्यामुळं पुढे होणाऱ्या न्यायाधीशाच्या परीक्षेसाठी हा एक उपक्रम डॉक्टर उदय वारुंजीकर आणि बार काउन्सिलचे सर्व जय भावे साहेब यांच्या प्रयत्नानं आपण सुरू केलेला आहे. अगदी 5 मिनिटापेक्षा कमी वेळ मी घेतोय, कारण आपल्याला रेवती ढेरे मॅडमना ऐकायचं आहे. फक्त एक सूचना देतो की अशा कार्यक्रमातून आपण अनेक न्यायाधीश, अनेक सरकारी वकील, अनेक जिल्हा न्यायाधीश तयार केले. त्याचप्रमाणे कंझ्युमर कोर्टाचे देखील प्रेसिडेंट तयार होतील आणि या उपक्रमानुसार फॅमिली कोर्टाचे न्यायाधीश देखील तयार होतील. येणाऱ्या काळामध्ये सगळ्यात महत्वाचं काम कोणतं असेल तर फॅमिली कोर्ट चालवणं आणि त्याच्या न्यायाधीशपदी बसून समाजामध्ये जो सध्या एक वाद सुरू आहे त्या वादामध्ये जास्तीत जास्त निराकरण आणि तेही सहमतीनं जास्तीत जास्त निराकरण करावं यासाठी प्रयत्न करण्याची एक प्रतिज्ञा आपण सगळ्यांनी घेतली पाहिजे. आज मी बार काउन्सिल ऑफ महाराष्ट्र आणि गोवा तर्फे आदरणीय ढेरे मॅडम यांचं स्वागत करतो, आभार व्यक्त करतो की इतकं बिझी शेड्यूल असताना देखील त्यांनी आज पहिलं लेक्चर साठी आपली अनुमती दिली. आपल्या मार्गदर्शनानं, आपल्या अनुभवानं अनेक महिला वकील आपल्यासारखे व्हायचा प्रयत्न करतील मॅडम, असं मला वाटतं. आपल्या पावलावर पाऊल ठेवून न्याय संस्थेमध्ये आपण बार काउन्सिल सर्व मिळून एक चांगला प्रवाह निर्माण करू अशी मला खात्री आहे. बार काउन्सिल कडून जे काही आवश्यक आहे ते सर्व सुविधा आवश्यकता पूर्ण केली जाईल. आमचे व्हाईस चेअरमन, ऍक्टिव्ह व्हाईस चेअरमन म्हटलं तर चालेल, आपल्या बरोबर आहेतच. त्यांना मी विनंती करेन की जास्तीत जास्त न्यायाधीशांच्याकडून यामध्ये लेक्चर्स ठेवावीत. मी कोल्हापूरचे जे न्यायाधीश आहेत, मला वाटतं आता साधारण 1 वर्षभर त्यांची सेवा राहिली, त्यांच्याशी बोललो आहे मी, ते देखील लेक्चर घ्यायला तयार आहेत. ऍक्च्युली आम्ही गेले 15 दिवस आमच्या इथे लेक्चर सुरूच आहेत, पण हा जो आजचा जो उद्घाटन सोहळा आहे यामुळे संपूर्ण महाराष्ट्र आणि गोव्यामध्ये आपण पोहोचेन असं मला वाटतं. आणि अत्यंत चांगले, सक्षम, अभ्यासू आणि कार्यतत्पर न्यायाधीश यातून निर्माण होतील अशी मी आपल्या सर्वांना शुभेच्छा देतो. आणि समाजामधलं सगळ्यात महत्वाचं काम हे कौटुंबिक न्यायालयाचंच असतं आणि या ठिकाणी आपल्यासारखे संवेदनशील लोक जर आले आणि आम्ही ते संवेदनशील लोक तयार करायला जर मदत आमची काही झाली तर तो आमचा खारीचा वाटा असेल आणि याबद्दल येणाऱ्या काळामध्ये आम्हाला त्याचा खूप आनंद होईल. मी पुन्हा एकदा आजचा हा कार्यक्रम सुरू झाला असं जाहीर करतो आणि संयोजकांच्याकडे देतो.
Thank you, sir. Now I request Advocate Dr. Uday Wadgurkar Sir, Vice Chairman of Bar Council of Maharashtra and Goa and coordinator of this lecture series, to give information about this lecture.
नमस्कार. आदरणीय न्यायमूर्ती जस्टिस डेरे आणि आपल्या सगळ्यांचं स्वागत. आमचे चेअरमनही आहेत. चेअरमन साहेबांनी जी काही गुणविशेषणं वापरली त्याबद्दल धन्यवाद चेअरमन सर. ऍडव्होकेट ऍक्ट मधल्या कलम 6 प्रमाणे स्थापित झालेली बार काउन्सिल ऑफ महाराष्ट्र आणि गोवा ही एक स्टेट बार काउन्सिल आहे. आणि जी वेगवेगळी जी कर्तव्य पार पाडायची असतात त्यातलं एक कर्तव्य हे या प्रकारचं आहे की ज्याला आम्ही ज्युडिशियरी ऍज अ करिअर असं त्याला आम्ही म्हणतो. ते वर्ष होतं साधारणतः 9 वर्षापूर्वी 2014, ज्यावेळेस तत्कालीन मुख्य न्यायाधीश होते जस्टिस मोहित शहा मुंबई उच्च न्यायालयाचे. त्यांनी आम्हाला विनंती अशी केलेली होती की ज्युडिशियरीच्या परीक्षेकरता अनेक विद्यार्थी बसतात, परंतु त्यांची तयारी ही अपेक्षेप्रमाणे नसते आणि त्याच्यामुळं खूप वेळा रिजेक्शनचं किंवा त्याचं निकालाचं प्रमाण खूप कमी लागतं. किंवा समजा आपण गृहीत धरू की 100 सीट्स आहेत तर चांगले कॅन्डिडेट 50 सुद्धा मिळणं अवघड होतं. अशा प्रकारची खंत त्यांनी व्यक्त केली होती आणि विनंती केलेली होती किंवा आदेश दिला होता म्हणूया की बार काउन्सिलने याच्यात लक्ष घालावं. त्यावेळेस 2014 सालापासून अव्याहतपणे ज्या ज्या वेळेस अशा प्रकारच्या परीक्षा येत आहेत त्या वेळेस बार काउन्सिलनी पुढाकार घेऊन ट्रेनिंगचे कॅम्प आयोजित केलेले होते. आपल्यापैकी काही लोकांनी पूर्वीच्या परीक्षांना आपण बसलेला असाल तर फॅमिली कोर्टाची 5 वर्षापूर्वीची परीक्षा जी झाली होती त्यावेळेस आपण एक चक्क असाच कॅम्प घेतलेला होता की जो मे बी विकेंड कॅम्प की ज्याच्यामध्ये 10 तास 12 तास 15 तास विद्यार्थी एकत्र बसून शिकायचे, चर्चा करायचे. परंतु त्या अशा प्रकारच्या फिजिकल कॅम्पना मर्यादा असते, कारण महाराष्ट्र हा प्रचंड मोठा विस्तारलेला असा राज्य आहे. गोवा देखील आपल्या बरोबर आहे, दीव दमण देखील आपल्या बरोबर आहे. त्याच्यामुळं कोरोनाच्या कालावधीमध्ये या ऑनलाईन प्लॅटफॉर्मचा कसा वापर करायचा हे आपण सगळेजण शिकलो आणि त्या बॅकग्राऊंडवरती त्या पार्श्वभूमीवरती बार काउन्सिलने असं ठरवलं की या परीक्षेला सुद्धा आपण विद्यार्थ्यांना तयार करायला पाहिजे. चांगला वकील हा चांगला न्यायाधीश बनू शकतो, परंतु चांगल्या वकिलांमधून चांगला न्यायाधीश बनण्याकरता जे काही कष्ट घ्यायचे असतात त्याला मार्गदर्शन करणारे अनेक चांगले वक्ते हे या निमित्तानं आपल्याला व्यासपीठावरती आपण त्यांना बोलवत असतो. चांगल्या वकिलामधून चांगला न्यायाधीश घडवण्याची जी प्रक्रिया आहे ही वेळखाऊ प्रक्रिया आहे, ही किचकट प्रक्रिया आहे. याला पेशन्स लागतात. याच्यामध्ये न्यायाधीश बनण्याचं जे एक वेगळं एक जे मेटल असतं, वेगळी जी क्वालिटी असते ती हळूहळू आपल्यामधली पुढे यायला लागते. येणं आवश्यक असतं, अभिप्रेत पण असतं. मग या कार्यक्रमाला मार्गदर्शन करण्यासाठी आम्ही ज्यांनी अशा प्रकारचे न्यायाधीश एलिमेंट जो आहे किंवा ज्युडिशियली चा घटक बनण्याच्या प्रक्रियेमधला जो काही जी प्रक्रिया त्यांनी पूर्ण केलेली आहे अशा सगळ्या लोकांना आम्ही या ठिकाणी बोलवतो. मग जे सब्जेक्ट एक्सपर्ट असतील त्यांना आम्ही बोलवतोय, त्याच्या बरोबरीनं जे ऑनरेबल जजेस आहेत त्यांना बोलवतोय, जे ऑनरेबल फॉर्मर जजेस आहेत बॉम्बे हायकोर्टाचे त्यांना बोलवतोय, काही जे सिटिंग जजेस आहेत त्यांना बोलवतोय, काही निवृत्त झालेले जे फॅमिली जज आहेत त्यांना बोलवतोय. असे करून हे कमीत कमी 15 दिवस रोज संध्याकाळी 5:55 पासून 1 तास 7 वाजेपर्यंत हा कार्यक्रम चालेल. आणि अत्यंत अभिमानाचा आजचा दिवस आहे की मुंबई उच्च न्यायालयामधल्या महिला सर्वात ज्येष्ठ न्यायाधीश जस्टिस रेवती मोहिते-डेरे मॅडमनी आमची विनंती स्वीकारली आणि त्या आज आपल्याला या कार्यक्रमाला उद्घाटक म्हणून मिळालेले आहेत. आम्हाला सगळ्यांना खात्री आहे की त्यांचा जो जीवन प्रवास आहे, त्यांचं जे काही आदर्श आपल्या सगळ्यांच्या समोर आहे तो निश्चितच स्फूर्ती देणार आहे. त्यामुळं अनेक हे सगळे जे काही विद्यार्थी आहेत, जे वकील आहेत वेगवेगळ्या तालुक्या आणि जिल्ह्यामध्ये काम करणारे, हे सगळे वकील या ठिकाणी स्फूर्ती घेऊन आपण जो काही आदर्श घालून दिलेला आहे त्याप्रमाणे निश्चितपणे काम करण्याचा प्रयत्न करतील. आजचं जे सॉफ्टवेअर आपण घेतलेलं होतं त्याला 500 लोकांची मर्यादा होती आणि बघता बघता अवघ्या काही मिनिटाभरामध्ये 500ची सॉफ्टवेअर मर्यादा पूर्ण झालेली आहे. उद्याच्याला असाच जर का आपला एकूण सगळा रिस्पॉन्स राहिला तर बार काउन्सिलच्या वतीनं आपण कदाचित 1000 लोकांचं देखील आपण त्याप्रमाणे सॉफ्टवेअर त्याच्यामध्ये व्यवस्था करूया. बार काउन्सिलच्या अन्य 24 लोकांनी मला कोऑर्डिनेटर म्हणून जी जबाबदारी दिलेली होती ती पार पाडण्याचा मी नक्की प्रयत्न करेन. प्रत्येक लेक्चरला मी नक्की हजर राहीन आणि आपल्याला नक्की मदत करेन एवढं सांगतो आणि सूत्र परत देतो. धन्यवाद.
Thank you very much, sir. It is my honor to introduce our today's resource person, Honorable Justice Srimati Revati Mohite-Dere Madam. Honorable Justice Srimati Dere Madam is a born scholar who has received National Merit Certificate for standing in the merit list in HSC, which, which she has completed from Ferguson College. Honorable Justice Srimati Dere Madam secured first class with distinction in BSL LLB and stood second in various lists of University of India. Honorable Justice Srimati Dere Madam studied LLM at University of Cambridge, UK, and is a recipient of the prestigious the Cambridge Commonwealth Trust Scholarship for LLM. Honorable Justice Srimati Dere Madam joined the chamber of her father, eminent senior advocate Vijay Rao Mohite at Pune, and thereafter the chamber of Barrister Raja Bhosle in Mumbai. Honorable Justice Srimati Dere Madam practiced in the High Court on the criminal, civil, and constitutional side, and also in Sessions Court. Honorable Justice Srimati Dere Madam worked as an assistant government pleader, writ cell at Bombay High Court appellate side, as a senior counsel, Group 1 and 2 for the Union of India, and as an additional public prosecutor for the Union of India in High Court, and also appointed as a government leader and public prosecutor for State of Maharashtra. Honorable Justice Srimati Dere Madam appeared in several important matters, including PILs and confirmation cases. Honorable Justice Srimati Revati Mohite-Dere Madam was appointed as an additional judge of Bombay High Court on 21st June 2013 and elevated as judge of Bombay High Court on 2nd March 2016. I request Honorable Justice Srimati Mohite-Dere Madam to guide us on the topic of family courts. Over to you, Madam.
Thank you. Advocate Vivekanand Bharti, Chairman of the Bar Council of Maharashtra and Goa, Advocate Bharti, Vice Chairman of the Bar Council of Maharashtra, Advocate Bar Council of India, other members of the Bar Council of Maharashtra, and all those advocates who are virtually present today, wishing you a very, in spite of all gains outside this platform has been amazing, as a result of which we can still continue with the program, which otherwise would not have been possible. At the outset, I would like to congratulate Bar Council of Maharashtra for organizing this online training virtual lecture series for all those who seek to take up judicial service as a career. It is a great initiative undertaken by the Bar Council under the dynamic leadership of the office bearers Bar Council. The response, as Mr. Varunjikar said, has been phenomenal, and it's a testimony of the work that Bar Council is doing, spread awareness of these kind of initiative and programs all across the state of Maharashtra. I am honored to inaugurate this virtual lecture series organized by the Bar Council for preparing all those who are present today for appearing post of family court judges. As all of you know, there has been a rise in the matrimonial litigation, which has led to the enactment of the Family Courts Act 1984 and the establishment of family courts in India. All of you are aware that the Family Courts Act was enacted to set up courts to deal with disputes concerning the family by adopting an approach radically different from that adopted in ordinary civil. Family courts were established to promote conciliation and to secure speedy settlement of disputes relating to marriage and family affairs and for matters connected with it. Family courts are expected to make efforts of settlement for the commencement of the trial. And therefore, the Family Courts Act is a unique feature, which is appointment of marriage counselors in family court. Of course, the first few family courts that were established were in Mumbai, Pune, Aurangabad, and Nagpur, and then we had family courts in Amravati, Ahmedabad, Thane, Nasik, Kolhapur, Nanded, Solapur, and so on. And under the 14th Finance Commission, the decision as per the guidelines is to establish at least one family court in each district. Accordingly, family courts are being established pursuant to the Finance Commission. We all know that family courts are flooded with litigation. And the main reason, there are several reasons for this, the rise in matrimonial litigation. And therefore, the endeavor of all concerned in the family court judges, the counselors and advocates, all practicing in the family court, is to remember that the effort should be towards conciliation, which is the very object of the Family Courts Act. The family court judges, counselors, and advocates all practice in the family courts have a huge responsibility. It is not just a case, but a case where people's emotions and sentiments are involved. It is a responsibility which each one has, which extends not only to the litigant, but to the society itself. Appearing for a litigant in a family dispute, particularly matrimonial matters, is a challenge faced by every member of the bar. He must remember that he is an officer of the court, an advocate, I must remember, and that it is his responsibility to see that even he takes steps or initiative and see that the matter is settled. As you all, marital issues are very sensitive. It involves emotions, human relationships, and most importantly, children. Children can be traumatized because of the dispute between the parents. It is the duty of all those involved in the process to protect the interest of the children. Children need the love and affection of both parents for their development. And we cannot forget that children are the future of tomorrow and they cannot be made to suffer. Of course, there are very important issues when a matter comes before the family court. If the couple is married with no children, that is settled. But where there are children involved, it becomes a tedious and an onerous task for everyone involved in the process, particularly when issues relating to child access, custody, and visitation rights, which are most important things in a dispute between the couple. There is a parenting plan which is there, but of course it is not mandatory. But an endeavor is made by courts to see if parties mutually agree, abide by the parenting plan, and give access other parent. Of course, it is an optional thing, but it is one good thing which an endeavor can be taken. The role of a marriage counselor is extremely important to see that the dispute is settled amicably. Of course, the marriage counselors cannot compel or force anybody to sign consent terms or to enter into consent. Their role is to see that the parties see reason, make them understand the impact divorces have on children, give them time to think and introspect. At times, the path for resolving disputes may be slow. There may be a few hiccups on the way, but the endeavor must be to see that the parties attempt, at least try and see that the matter can be amicably resolved between the parties. It does not mean when we say amicably resolved that they have to come back together, because which is that, but they also can part amicably without doing any mudslinging in the process. Family courts have to be responsive to the needs of the people for whom it is established. and must discharge his duty, keeping in mind the object for which the family courts have been established. There must be an endeavor to bring about reconciliation, as I said earlier, with disputing couples, and to save marriages by either uniting them or helping them happily part ways. There have been cases as a guardian judge of the family court in Western Maharashtra for quite a few years. There have been programs which have been led by family courts where parties who have filed for divorce or who have approached the family court after 5, 6, and who have even got divorced have come back together, have got reunited, and have started the program called Nanda Sautra, something that effect. So where in Nagpur we had felicitated about 100 such couples, even after having parted ways, came back together. So sometimes it may not happen in the family court, it may happen, doesn't happen in the High Court, it happens in the Supreme Court. But endeavor is to not to lose hope and to make an endeavor to see that the parties try and work out an amicable settlement. Now, the qualities that are required of a family court judge those qualities are extremely important, which is empathy, being impartial, being an extremely good listener, because that's what the parties want, and patience, patience, and patience. I've always appreciated all the family court judges who work in the family court because it takes a lot of time, effort to make an endeavor, make parties settle the matter. There is no greater satisfaction in trying to resolve a matter than to deliver a judgment. Even in fact, when the matter comes before us, we make an endeavor to call the parties to the chambers and try to see if they can resolve their matters and narrow down their differences. And yes, there is great satisfaction when you're able to. And I think all the family court judges in Maharashtra have been really taking a lot of pains, efforts to see that the matters are settled. Now, even before, sometimes what happens is, of course, when the parties file a petition before the family court, goes before the marriage counselor, and then before the judge, after that to the judge. But Maharashtra Legal Services Authority had started a project called Let's Talk, which is a pre-litigation center, of which I'm also a part, where and when I was sitting with Justice Oak, and as he then was a judge, we realized that by the time the matters came to the High Court, the parties were so bitter that they refused to settle. And they would say that now 20, 30 years have passed and now we don't want to settle. So the bitterness becomes greater and greater with time. So therefore we felt that it is important that something must be done even before the parties approach the family courts. And therefore, in that direction, we have started this program called Let's Talk, which is a pre-litigation center which we have in Mumbai, Aurangabad, Nagpur, and Thane, and several other places started. We have started in Amravati also. So we thought that if we are able to settle one matter in this pre-litigation center, we have addressed 4 or 5 litigations which happens in the matrimonial dispute. It could be in the rise of the form of a 498A case. It could be in the form of DD proceeding, happen for the family court. So therefore, the endeavor was to start a pre-litigation center, address this issue of matrimonial dispute. Because the minute pleadings are filed, then there is 498A cases filed, then there is bitterness as a result of which it becomes difficult. That is the matter. There is also a center which has been started by Maharashtra Legal Services Authority, which is called the SUPUL, which is the post-litigation center, where parties can be sent after during the pendency of the litigation. And I must say that we have done very well in both pre-litigation center and as well as post-litigation center by resolving disputes between the parties and help parties amicably settle dispute. You must remember that people who come to the family court come with a lot of baggage of emotions, whether hatred, sadness, anger, any of the emotions, feeling of sadness. So it is important that we understand that these are the kind of emotions which parties come with, and therefore it is important, as I said, the qualities should be such that you must ensure that the parties are made to feel comfortable, and therefore patience is probably the key thing for any judge in dealing with family court matters. That is the true skill which a family court judge really requires. We have a lot of eminent speakers who will also be speaking to all of you on different topics, and they will be addressing you on different topics. And therefore today I will just talk to you about, give you a very overall view of some judgments which are very important and therefore which need to be kept in mind when appearing for your when you are preparing for your examinations for this post as a family court judge. Before I go to the judgments, you must remember that under the Family Courts Act, what is important and what is permissible is that you can seek assistance of medical and welfare experts. Now, every family court has to draw up a list of NGOs. They can contact a psychiatrist, a psychologist, who can aid and assist the counselor and the family court in a given case where you can refer the parties or if as depending on the case. And therefore, this is permissible under the Family Court Act, and it's important that every family court has this kind of welfare experts or medical experts can guide them whenever the need arises. As I always say, that family court is not the nicest of place for any child to be given access. It should be a neutral place, but again, it would depend on the facts of a given case where access can be. Sometimes one of the parents can be extremely uncomfortable giving the child access to other parent, fearing that the child will be taken out of custody. So, of course, this will be depending on the facts of it. Now, certain judgments that I wish to bring to your notice, and which you can take down the citation so that you can keep these judgments in mind. One is Mohan Singh versus Meena. It is reported in 2006, SCC 350. I'll repeat again, 2015, 6 SCC. It talks about the duty of a family court. It says that a family court should remember that procrastination is the greatest assassin of the list before it. It not only gives rise to more family problems, but also gradually builds unthinkable and everlasting bitterness. It leads to the cold refrigeration of the hidden feeling still there. The delineation of the list by the family court judge must reveal the awareness and balance. Dilatory tactics by any of the parties has to be sternly dealt with. or the family court judge has to be alive to the fact that there is a need to decide matters expeditiously, keeping in view objects and the Act and the scheme of various provisions pertaining to grant of maintenance, cost, custody of child, property issues. The case, this particular case of Bombay also discusses in detail the very objective as well as the intention of bringing the Family Courts Act by legislature. And therefore, this is a judgment which all of you can as part of your preparation for the examination. The other judgment is the judgment of Gaurav Nagpal versus Sumedha Nagpal. This is reported in 2009, 1 SEC 42. I'll repeat again, 2009, 1 SEC 42. This is a case which involves the custody of the child in relation to a minor child. It says that the principles in relation to custody of a minor child are well settled. In determining the question as to who should be given custody of a minor child, the paramount consideration is the welfare of the child. The moral and ethical welfare of the child must also weigh with the court as well as its physical. So this is one judgment which is a good read and you must read this. It also deals with the provisions of special statutes under the Hindu Minority and Guardianship Act, which govern the rights of parents, which can be taken into consideration while deciding custody matter. And of course, says that nothing can come in the way of the courts exercising parents' parentage. So, in this very topic of custody, apart from Gaurav Nagpal, subsequent judgment of Vikram Mohite-Dere versus Shalini Bhalla, which is reported in 2010 for SEC 409. I'll repeat again, 2010 for SEC 409. This is again which pertains to a child custody order. Now, the facts of this case was that the husband, this was before the apex court, the husband had filed a petition in the Supreme Court against judgment and order of the High Court, which had upheld order of the district judge in relation to applications filed by both the parties, that is by the husband and the wife, under section 26 of the Hindu Marriage Act. The child was 7 years old and the custody was decided by mutual consent under a section 13B petition between the husband and the wife. As per the terms of settlement, the father would have the right of visitation as stipulated in the consent term. Both the parties had agreed that they would not obstruct any of the other parties in the implementation of that arrangement. Certain other terms and conditions also stipulated. What happened is that subsequently the wife got a job in Australia. Earlier, both the parties were in. Therefore, the wife filed an application before the district court and applied for modification of the terms and conditions with respect to custody of the child. The father was also filed an application saying that permanent custody of the child should be given, considering change of circumstance, and that it would not be in the interest of the child to be in there permanently. The trial court allowed the wife to take the child to Australia, but also directed her to bring the child back to India for allowing the father visitation rights twice in a year for 2 terms, and with the stipulated order. Of course, the child was interviewed at all stages, at all levels. The child was 7 years old, told the court that he would want to meet the mother. Court also, after speaking, it is important, we must know whether the child is tutored, not tutored, found him to be intelligent enough to make a conscious decision when he wanted to. So therefore, the court in this case, that is in Vikram Bora's case, held that in a matter relating to custody of a child, the court must remember that it is dealing with a very sensitive issue in considering the nature of care and affection that a child requires in the growing stages of her life. That is why custody orders are always considered interlocutory orders. And by the nature of such proceedings, custody orders cannot be made rigid and final. They are capable of being altered and molded, keeping in mind the best interest of the child. Therefore, it is important to bear in mind that these are interim or interlocutory orders and not final orders, because the circumstances may change with passage of time, giving a right to either of the parties to file an application seeking modification of the terms. In fact, in Rosie Jacob, this is referred to in this very judgment of Vikram Bora, a three-judge bench of the Apex Court held that all orders relating to custody of minors were considered to be temporary orders. The learned judges made it clear that with the passage of time, the court is entitled to modify the order in the interest of the minor child. The court went to the extent of saying that even if orders are based on consent, those orders can also be varied with the welfare of the child who demands. So that it all depend on the facts and circumstances of every case. Again, in this Bora's judgment, Gaurav Nagpal, which I referred to here, the principles which have been set out in paragraph 42 and 43 of that judgment have been reiterated. Respect to the what is the paramount consideration, which is the welfare of the child. And in para 18 of Bora's judgment, ultimately what court held is that the respondent, that the mother, the wife, was getting a better job opportunity in Australia, and her autonomy of her parenthood, personhood, cannot be curtailed by the court on the ground of a prior order of custody of the child. It held that every person has a right to develop his or her potential. In fact, a right to develop is a basic human right. The mother cannot be asked to choose the child, and it was held that the child is very dear to the mother and she will spare no pains to ensure that the child gets proper education and training in order to develop his faculties and ultimately become a good citizen. The custody of the child is denied. The mother, she may not be able to pursue her career in Australia, which may not be either conducive either to the development of a career or to the future prospects of the child. Of course, while doing so, a balance was struck and the mother was directed to bring the child to India on twice in a year that the father could get access, and an undertaking was taken from the mother that she will comply with it. So this is with respect to custody. Now, coming to the I'm just highlighting a few of the topics. Of course, the speakers that will be speaking on this topic will be. Next judgment, which I think is important, is with respect to child repatriation, because there are not many cases that come these days and which are seen where the couple has got married in the USA or in Australia, and the one of the parents brings the child to India, and then custody orders are passed by the US, not by the court, and the mother doesn't want to take back the child. So these kind of cases are also on the rise. So a judgment which is there on this point with respect to child repatriation, judgment of Anand Raghavan versus state, that is NCT of Delhi and another. It is reported in 2017, 8 SCC 454, I repeat, 2017, 8 SCC 454. This is with respect to child repatriation, foreign orders. Now, in this case, the Supreme Court in paragraph 42 has observed that in kind of cases, when the child is brought to India, the courts in India are to conduct, there are two kinds of inquiries, either a summary inquiry or an elaborate inquiry on the question of custody. Now, what is summary inquiry and what is elaborate inquiry has also been detailed in this judgment, which you can post. It is held in this case that in case of summary inquiry, the court may deem it fit to order return of the child to the country from where he or she was removed, unless such return is shown to be harmful to the child. In other words, even in the matter of summary inquiry, it is open to the court to decline the relief of return of the child to the country from where he or she was removed, irrespective of a pre-existing order of return of the child by a foreign court. In an elaborate inquiry, the court is obliged to examine the merits as to where the paramount interest and welfare of the child lay and reckon the fact of a pre-existing order of a foreign court for return of the child as one of the circumstances. It was held that it is settled legal position that the concept of foreign convenience has no place in courtship jurisdiction. So this would depend on on case to case, but what is important is that a summary inquiry and an elaborate inquiry conducted. And even if there is a foreign order, that can be considered as one of the circumstances. But in both the inquiries, what is of paramount consideration, welfare and the interest of the child. So this is one judgment which deals with judgments right from Meki versus Meki, which is a Privy Council judgment. So this is a judgment which all the judgments have been discussed. And I think this is one judgment as far as on child repatriation and foreign orders is concerned. Now coming to another point, which is mental cruelty. This is a case where what is mental has been discussed, and the judgment in this case that of Dr. Mohite-Dere. Mohite-Dere versus Dr. V.V. Ravi. This is citation is not available, but it arises out of a civil appeal apex court, civil appeal number 5862 of 2014, which arises out of a SLP number 17 of 2010. Now, in this case, in paragraph 24 onwards, the apex court has discussed the issue of what is mental and how the concept has been by the apex court. Right from Vineet Saxena versus Pankaj Pandit, it has dealt with all the cases, what is to be considered as mental. It has quoted Vineet Saxena versus Pankaj Pandit, which is of 2006, the SEC 77. that it is settled by a catalogue of decisions and mental activity can cause even more serious injury than the physical harm and create in the mind of the injured appellant such apprehension as is contemplated in the section. It has to be determined on whole facts of the case and the matrimonial relations between the spouses. To amount to cruelty, there must be such willful treatment of the party which caused suffering in body or mind, either as an actual fact or by way of apprehension, in such a manner as to render continued living together of spouses harmful or injurious, having regard to the circumstances of the case. In this relation, it held that the culture, temperament, status in life, and many other things are the factors which have to be considered. Similarly, it has quoted the judgment of the apex court itself in Samar Ghosh versus Jaya Ghosh, which is reported in 2017 for SCC 511, where certain illustrations are set out. Of course, they are only by way of illustration and not exhausted, as to what from those examples were from inference of mental and not. Take for example, it is further stated there are about a couple of illustrations which have been set out. This judgment. Similarly, what is quoted is also a judgment again of case of Vishwanath Agarwal versus Sarla Agarwal as to what is mental has been opined by the apex court that the expression cruelty has an inseparable nexus with human contact or human behavior. It is always dependent upon the social strata or the milieu to which the parties belong, their ways of life, relationship, temperaments, and emotions that have been conditioned by their social status. It has been held that in another case that even responsible publication in newspapers or humiliating the husband can, in a given circumstance, call mental cruelty. So this is one judgment where there are several judgments discussed of the apex court, which you can also go through as part of your preparation for the exams. Now coming to the next topic, I have just chosen one judgment for each of the topics so that then which has a reference to several judgments in that very judgment. Now coming to the next topic is that of maintenance for live-in partners. This is the judgment of Lalita Topo versus State of Jharkhand. It is reported in 2019, 13 SCC 796, I repeat, 2019, 13 SCC 796. Now, this was a case where the appellant was in a live-in relationship and out of which she had also had a child. One of the issues before the apex court was whether a man and a woman living together as husband and wife for a significant period of time would raise the presumption of a valid marriage between them, or whether such a presumption would entitle the woman to seek maintenance under section 125 CRPC. Although the apex court declined to answer the question, saying that the questions do not require any answer as the appellant had availed of a remedy under the Domestic Violence Act since she had suffered economic abuse from a partner. She was directed to approach DV court and a matter was directed for expeditiously. Now coming to one more judgment which is also important in terms of family court, which is cases of divorce by mutual consent. Whether the waiver can be there for 6 months can be done or not. Judgment in this context is that of Amardeep Singh versus Harveen Kaur. It is reported in 2017, 8 SCC. I repeat, 2017, 8 SCC, 786. Now, the issue arose in this appeal was whether the minimum period of 6 months stipulated under Section 13B Marriage Act in a suit for decree of divorce based on mutual consent was mandatory or could be relaxed under exceptional situation. The court, whilst dealing the same, para 19 observed that we are of, and I quote, that we are of the view that where the court dealing with the matter is satisfied that a case is made out to waive the statutory under Section 13B, bracket 2, it can do so after considering the following, which is 1, the statutory period of 6 months specified in Section 13B2, in addition to the statutory period of 1 year under Section 13B1 of separation of parties is already over before the first motion itself. Or 2, all efforts for mediation or conciliation, including efforts in terms of Order 32A PCPC or Section 23(2) of the Act or Section 9 of the Family Courts Act to reunite the parties have failed, and there is no likelihood of success in that direction by any further courts. Third, the parties have genuinely settled their differences in alimony, custody of the child, or any other proceeding, pending issues between the parties. And fourth, the waiting period will only prolong their agony. They observed in para 20 that Section 13B is not mandatory but directory, and it will be open for the courts to exercise its discretion. The facts and circumstances of each case, where there is no possibility of parties resuming cohabitation and there are chances of alternative rehabilitation. So these are some of the important judgments with which you will be concerned with when you will be appearing for your examination and thereafter even subsequently. It is important to know your basics, which is all the acts with which the Family Court Act deals with, the rules of the Family Court, and how in a given situation would deal with custody matters, access matters. And most important, what is important for a good family court judge quality is sensitivity. Sensitivity, all the issues that a person faces. I can tell you, family court in Pune, one of our family judges, Swati Chavan, has started a very good project because what used to happen is women from an extremely poor section of the society would come and would get a very powerful, the husband is a rickshaw driver or is not doing daily wage labor. How much maintenance could she give? The husband gave 500,000, and then the wife had to come every time to the family court and for execution of and saying that the money is not deposited. Woman would be sad, dejected, upset, and her, entire, she would lose hope. And if there is a child, then it gets worse. So what was started by Mr. Chavan Family Court is a program called Swam Siddh for the women. So the counselors, marriage counselors, would identify the candidates for such this program, obviously from weaker sections of the society. So depending on their choice, their vocation, what they would like, whether they would like to learn tailoring, would they like to do a course in beauty parlor, driving, whether they wanted to learn stitching, and so on. So this was tied up with the Rotary Club, and we saw a phenomenal difference in overall, the overall look of the woman in the end, at the end of the after finishing her vocational training. We had this program in Pune for this for all the women who had undergone this program tied up with Mohite-Dere, and they came out as different, completely different women. They were so positive. They felt that they had to stand on their feet, that they could do something, and the project was such that in some of the cases the husband and wife came back together. In some of the cases. So the idea of telling you is that the scope of a family court judge is not of judgment, but it extends to even something more than that, which is in a sense of social responsibility to the litigants, like this project called Swayam Siddha programs for non-custodial parents, for custodial parents, having workshops on Children's Day, having programs which other courts may not have. So this is the drive that you have to have in every person when you are applying for a post of a family court judge. The willingness and wanting to do something different for the people come there and see that true sense they achieve the object of happiness and justice. So these are some of the projects, and this project was extended to various other places, and it's still going on. And I think this is a phenomenal idea which one of our family court judges came up with. And these are something which each one of it is expected that when they get the opportunity, must think out of the box and do something which will enhance the status of the woman from where she is, so that she learns to stand on her own. So these are things that sky's the limit that you as a family court judge. So as I said right at the beginning, extremely satisfying for any family court judge, not only be able to settle a dispute, but even to go beyond that to do something for the people that come. So I'm sure that you will be enlightened by a lot of eminent speakers who will be speaking on various topics during the next 14 days that you are being trained virtual mode. And you will benefit a lot from all of them because their experience is tremendous in the field of family court and on the topics on which they will speak. I think this is a great initiative which the Bar Council has come up with. And looking at the sheer number of participants in this program, it is very heartening to know that there are so many people who want to get into this, look at this as a judicial career, the prospect of joining the judicial services. I wish each one of you all the very best. Thank you for inviting me. Thank you.
Before the vote of thanks is proposed, there is one announcement. This lecture delivered by Justice Dere will be uploaded on the YouTube channel of a Bar Council. And those who have missed this session, this lecture, for whatever reason, they can visit the official website, official YouTube channel of a Bar Council of Maharashtra and Goa. Now let us go back to the coordinator who will make the announcement for tomorrow. And before that, there is a small one request. I know everybody was looking great on the camera, but that's a distraction for the honorable speaker. So for tomorrow's lecture, please put your camera off along with the mic so that we can enjoy the lecture and concentrate in this lecture. Let us go back to the coordinator who will propose a vote of thanks. Coordinator, please.
Thank you, sir. On behalf of Bar Council of Maharashtra and Goa, I express gratitude and thank Honorable Justice Srimati Revati Mohite-Dere Madam for having consented to grace this inaugural session of the Family Court exam series and delivering a lecture on the topic of family law. Madam, in a very lucid manner, has highlighted the nuances of the object of the family court, the important qualities of the family court judge, most important being empathy, sensitivity, and patience. She has further very beautifully highlighted the important provisions of this statute, which play a role in the practice as a family court judge. She has also highlighted how this litigation is different from the other statutes. She has also shared important judgments on the family law, and certainly the knowledge shared by Madam will go a long way and help the aspirants of this family court exams. I express extreme gratitude on behalf of Bar Council of Maharashtra and Goa to Madam for having shared this knowledge with us. I also thank Honorable Chairman Sri Vivek Gadge sir and Honorable Chairman Dr. Uday Prakash Varunjikar sir, other Honorable BCI member Jayant Jaibave sir, and other esteemed members of the Bar Council of Maharashtra and Goa, and all my fellow coordinators for being present for this inaugural session. There are few instructions. Thank you, Madam, for being present. There are few instructions for tomorrow.
Yes, please continue.
Yes, there are few instructions for tomorrow. We will have a tomorrow lecture at the same time, and it will be by Advocate Prosper D'Souza on Christian law. The aspirants are requested that not to put on the mic and the camera during the lecture, so that we do not distract the speaker who has consented for our help for this examination. And further, if there are any queries, put in the chat, which will be taken into consideration and answered. Even the lectures, if in any manner are missed, they are being uploaded, and so therefore, if there is any miss out, you will be able to hear them later on. Sir, any more instructions?
Very good. Very good.
Thank you. Thank you.
Thank you.